Negotiating an injury settlement with an insurance adjuster is a lot like playing in a high-stakes poker game. The problem is you're not going to win unless you know what you're doing, and most people don't. It's like a poker pro playing against someone who's never played before, and the poker pro knows you haven't played before. So while you're still trying to figure out if 2 pair beats 3 of a kind, your opponent is check-raising you, running bluffs, and trying to steal all your chips. If this sounds familiar, you're going to want to watch this video. Today, I'm going to teach you some strategic power questions that you can use during your settlement negotiations to show the insurance adjuster you're not a newbie and you won't be bluffed off a big hand. Okay, enough poker analogies, let's get into it. The first power question that you want to ask an insurance adjuster is, what are the policy limits of your insured? The policy limit is the maximum amount that the insurance company is obligated to pay under its insurance policy issued to the policyholder. This is important information to have because the policy limit is the absolute most that you can get from the insurance company in a settlement for your injury claim. And in most cases, it sets the upper limit on how large a settlement you can get. For example, let's say that the at-fault party has an insurance policy with $100,000 in coverage for bodily injuries. That is known as the policy limit, and that's the absolute most that the insurance company is obligated to pay for the injuries caused by their insured. Now, let's say that the value of your injury case is worth $150,000. Now, in negotiations, the insurance company offers you the full policy limits of $100,000. Even though that's below the value of your case, in a lot of cases, it's the only money available to compensate you for your injuries, so that's the best you're going to do. It's also important to ask about the policy limits because an adjuster's response to this question can also give you some insight into how they're evaluating your case for settlement. If the adjuster refuses to tell you the policy limits, that can be a sign that there's a large policy limit or the adjuster does not believe your claim is worth whatever the policy limit is. So what should you do if the adjuster doesn't tell you what the policy limits are? Well, some states have laws that require them to. So if you live in one of those states, you can send a formal written demand that the limits be disclosed, and that should get the job done. In states that don't have those kinds of laws, there are a few things you can do to put pressure on the adjuster to disclose the limits. You can tell the adjuster that you're unwilling to negotiate without knowing what the policy limits are. You can also tell the adjuster that if they do not disclose the limit, you're going to consult with an attorney to file a lawsuit. Now, adjusters don't want attorneys involved because studies have shown that insurance companies end up paying out over 300% more on average to injury victims who have legal representation, which I talked about in another video. And it's the adjuster's job to pay you as little as possible, so they might disclose the policy limits to dissuade you from getting an attorney. The next power question you'll want to ask is, what is your settlement authority? Every adjuster has a limit on how much they can settle a case for, and it's not always the same as the policy limits. For example, the policy limits may be $100,000, but the adjuster assigned to your claim only has authority to settle cases for $50,000 or less. It's important to know this because the claims are assigned to adjusters based on how much the insurance company believes the case is worth. So if your claim is assigned to an adjuster who only has $50,000 in authority, that is likely because the insurance company is valuing your claim at $50,000 or less. And that's important to know because if your claim is worth more than $50,000, you might need to take some steps to escalate your claim to an adjuster with higher settlement authority. You can do that by requesting to speak with an adjuster's supervisor or provide more information about your injuries and treatment that show the value of your claim exceeds the adjuster's settlement authority. Now, just because you ask doesn't mean the adjuster is going to tell. Adjusters often refuse to disclose the amount of their settlement authority because they want to settle your case for as little as possible, and they don't want you to know the upper limit of what they can pay. But it's still a good question to ask because it sends the message to the adjuster that you are knowledgeable about the insurance claims process, which may encourage the adjuster to take your claim more seriously and discourage the adjuster from making a lowball settlement offer. Now, on to power question number 3. Do you agree that your insured is at fault? This question helps you understand the insurance adjuster's viewpoint on the fault or liability in the accident. And this is important because if the insurance company believes that you were partially at fault for causing the accident, that could reduce the value of your claim by the percentage of fault assigned to you. For example, if the insurance company assigns 20% of the fault to you, that means they're discounting the full value of your claim by 20% or more. And you may disagree with that, but at least now you've identified a potential barrier to settlement that you can try to address. Power question number 4. What do you have for the dollar amount of my medical bills? Medical expenses form a substantial chunk of your claim, and any disagreement over the total can lead to a reduced settlement. So you want to make sure that the adjuster is taking into account the full amount of your medical bills. Same for lost wages and any other out-of-pocket costs that you want to be reimbursed for in your settlement. Power question 5 is, what other information do you need to put more money on my claim? Now, adjusters generally aren't going to volunteer any suggestions to help you get paid more money. Their job is to pay you as small amount as possible. But sometimes towards the end of the negotiations and it looks like a settlement is going to be difficult to reach, we will ask the adjuster if there's any other information we can provide to them to help them kind of see things our way. This is just another way to try to get their perspective on your claim so that you can address any barriers to settlement. Adjusters at major insurance companies also use sophisticated software programs to value injury claims based on the information that the adjuster puts into the computer. Adjusters generally have to stick to the settlement range that the computer kicks out, and the only way to get that number higher is to feed the computer more information to increase the value of your case. Let me just give you a quick example. I just wrapped up a car accident case where my client had a severe concussion along with some soft tissue injuries. His head injury gave him a lot of problems over the next year. Headaches, mood swings, sensitivity to light and sounds, depression, and all kinds of other things. Fortunately, his symptoms got better over time, but it was clear from his medical records that he had a traumatic brain injury, which is an injury that can easily command a 6 or 7 figure settlement, sometimes even more. So I was shocked when the adjuster made a final offer of $30,000 on his claim. I called her up and I said, "What the heck am I missing here? Why is your offer so low?" Well, she told me that she agreed that it sounded like my client had a traumatic brain injury from the symptoms he was experiencing in his medical records, but she told me that none of the medical records actually had a diagnosis code for a traumatic brain injury. Sometimes medical providers don't always put in all the diagnosis codes, especially if there are multiple injuries or they use a diagnosis code that really doesn't fit the true nature of the injury. The diagnosis code my client's doctors used was for simple headaches, which aren't always associated with a TBI. And without my client having an actual TBI diagnosis, the adjuster was unable to get her company's software program to value the case like a true traumatic brain injury case. Well, now that we knew that, we were able to address the problem by getting my client's doctor to write a letter explaining that he believed that my client suffered a traumatic brain injury and that the traumatic brain injury was caused by the car accident. Now, this gave the adjuster the information she needed to adjust the value of the claim in her computer system, and we later got a policy limit settlement for my client. Power question number 6. Will another adjuster be assigned to my claim if I file a lawsuit? A lot of insurance companies will reassign a claim to a different adjuster if the case gets filed in court. Usually the new adjuster will have more authority to settle your claim, which can be to your advantage if the original adjuster just didn't have enough settlement authority to resolve your claim for fair value. But the main point of asking this question is to signal to the adjuster that you are thinking about filing a lawsuit. And adjusters generally don't want that because their job is to settle as many cases as they can, as quickly as they can, and as cheaply as they can. So if a claim goes into litigation, it reflects poorly on their job performance. If they know that you're considering a lawsuit as a next step, that might motivate them to put more money on the table or request more authority to settle your claim from their boss. Now, power question number 7 is sure to get under an adjuster's skin. How many times have you made an offer that was rejected, went to trial, and then a jury awarded a higher amount. Adjusters don't like this question because it's essentially asking them how many times have they been wrong about their case evaluation. The adjuster is not likely to answer this question, and if they do answer it, the answer probably won't be the truth. But the answer doesn't really matter because the point of asking this question is to communicate that you are ready to take the matter to court if necessary. Again, that's something that most adjusters want to avoid because it can hurt their job performance evaluations. Now, I want you to understand that asking these questions is not about being confrontational or difficult. It's about making sure you have the information you need to successfully negotiate with the insurance company, maybe gain some credibility along the way, and hopefully get the highest settlement possible. Watch this video here if you want my top tips on preparing to negotiate with insurance adjusters. And if you want me to take a look at your case, you can use the link in the description below to get a free case review. Thanks so much for watching. We'll see you in the next video.